Hello, my name is Daryl Weilberg, and I am a Jehovah's Witness in good standing, or I'm one of Jehovah's Witnesses in good standing, whichever you prefer. Grammatically, both are correct. This video is not approved by the Watchtower Bible and Tract Society of Pennsylvania. It's not approved by the Watchtower Bible and Tract Society of New York, and it's not approved by the Faithful and Discreet Slave, or the governing body of the Jehovah's Witnesses, located there in Warwick, New York. And it's not approved by any local body of elders. I don't work for the elders. I don't work for the Faithful and Discreet Slave, or the governing body, and I don't work for the Watchtower Bible and Tract Society. In fact, none of the 9 million Jehovah's Witnesses work for them. We work for Jesus Christ, all 9 million of us. Scriptural reference to that is Matthew 23:10. I'm going to give you an update today on the court system. I've got 2 appeals pending in the Second Circuit Court of Appeals. Actually, I have 1 appeal, and the other case, I'm asking the Second Circuit Court of Appeals if I can file a Rule 60B motion with the District Court in the matter of Ethan C. Coase, Trooper, New York State. Now, this is how I see it. Now, be advised, this might not be how the Second Circuit Court of Appeals sees this, but this is how I see it. Trooper Ethan C. Coase was told by Robert Altman that Robert Altman disconnected my internet service on March 12, 2022. Now, Coase told Richard Castlein, Andrew Catello, the IT guy, Norman and Diane Button, that it was best to cut me out of the internet. Now, here's the point that we're trying to make, is that if you listen to the videotapes that Trooper Ethan C. Coase took on March 12th, you'll have to agree that they violated the law. They violated the law. Not me. They violated the law. And it's different timestamps and stuff, and I'll go into that in the next video. But here's the point. Ethan C. Coase told Trooper Ethan C. Coase told Robert Altman and the rest that it was okay to disconnect my internet accessibility. Now, Coase Robert Altman told Coase that he changed out the modem in the morning interview on March 12th. If you change out the modem, you have to have a new password. Or you can have the same password, but there has to be a password. I wasn't given any password, and it wasn't the same password. Now, again, in the afternoon version, Diane Button told Trooper Coase 3 times, that Robert Altman cut off my internet because he didn't like what I was doing with the internet. Now, basically, Richard Castlein, Robert Altman, Andrew Catello committed a Class A misdemeanor when they cut off my internet service. And you can see that in New York RPAPL, Section 768. You're going to read all about the statute there. Trooper Coase then conspired, and when he told them to cut me off the internet. Now, when Robert Altman changed out the internet, the modem, which would require a new password, he discontinued my use of the internet in violation of the law. That's Section 768, which was a misdemeanor. Now, that should have been the end of the interview right there. Trooper Coase, representing law enforcement, should have told them, you folks committed a Class A misdemeanor when you disconnected his access to the internet. A protected utility under New York RPAPL Section 768. But it did not end there, as it should have. Trooper Cross went on to commit a Class B felony. That's right. Now, how do I come about that? Well, the Class B felony is kidnapping. When he arrested me and transported me, took me from there at 4899 Bear Path Road, and took me to the Oneida City State Trooper headquarters, New York State Trooper headquarters, he kidnapped me. He didn't have legal probable cause, and no matter what the other courts say, they had no probable cause to arrest me. None. Because they committed the crime of disconnecting my internet, which I had the right, pursuant to the First Amendment, to reconnect. Because they didn't do it lawfully. Now, if you look at penal law, New York Penal Law, Section 135.20, Coss and his fellow officers committed this Class B misdemeanor or felony when they arrested me again on May 10th. So twice now we've got 2 felonies that these idiots committed, 1 misdemeanor and 2 felonies. Now, I allegedly committed the crime of criminal trespass, New York Penal Law, Section 140.15. It's called criminal trespass. Now, under this section, as a Class 1 misdemeanor, and when I entered the Richard Castling twice, the residence of Kiss on March 12th, to reset the internet router, that's what they charged me with. They charged me with criminal trespass. But I was the caretaker. And I don't care what Judge Sain says in her order, because, and with all due respect, this lady judge is all out of line, is way out of line here. She didn't do her job. Okay, I'm sorry, but she didn't do her job. They didn't look at the statute, and they didn't look at the videotapes where they admitted that they violated the crime on Section 768. Now, me entering the Castle Lane residence, I've been doing that for 6 years. I'm the caretaker of the property. And I was employed as caretaker until April 7th. No matter what Judge Sain says, Judge Sain, you can make up all you want of what happened, but you can't change the facts. I got the April 7th memo from the attorney, Bond and Associates, who represented Castle Lane. That's when I was terminated, April 7th, 2022, not before March. So Trooper Cross and his buddy, Trooper Cross committed a Class A. He conspired to commit a Class A misdemeanor when he instructed them to cut me off the internet. And then, of course, him and his fellow officers committed 2 Class B felonies, kidnapping. And one, they held me for 6 hours. Now, pursuant to 135.20, this is kidnapping in the second degree. A person is guilty of kidnapping in the second degree when he abducts another person. Period. Cross abducted me, transported me to the Oneida City Court, or not the trooper headquarters there in Oneida City, and then he fingerprinted me, and then he took me. Another cop brought me back home. And then on May 10th, a month later, they did it again. They arrested me again under false pretenses, kidnapped me, and kept me in 6 hours. Now, had they kept me in jail for 12 hours, they would have done the Class 1 or Class A felony. That's even worse. But they didn't. So, fortunately for Trooper Cross, they only held me in jail for 6 hours. So let's sum this up. Trooper Cross had no probable cause to arrest me on March 12, 2022, or on May 10, 2022. I was exercising my right to freedom of speech, freedom of religion, and freedom of the press. When I entered the Castle Lane residence in an attempt to connect the internet after Castle Lane and Company disconnected my internet access, Again, in violation of New York RPAPL section 768. You folks can look it up. It's on the internet. Trooper Coles was so locked on me, allegedly, that he not only blanked out their crime against me, he conspired with them to commit a crime against me. And he said it was best if you cut me, off the internet. That's what he said. It's in the video. I can't change it. You can't make this stuff up. Now, I may have this incorrect, but that appears to me to be approval, of course, for the alleged victim and witnesses to continue to commit the crime against me. In fact, at the very least, it is a conspiracy to commit the crime. Again, I do not know what the Second Circuit Court of Appeals will rule. That court could ignore the videos, the body cam videos. It could rule the videos will not be entered into the record. They could hold that I should have brought this up before, but then that would be contradictory to the facts and evidence, because the district court has about 4 copies that I've submitted of each of my videos. Now, if they allow the body cam videos into evidence, which they should by rule, the court must treat pro se litigants liberally. So every time a pro se litigant goes in, they can't hold these guys to the standard of they do of trial attorneys. How can that be? So Judge Saines says I want another bite of the apple because I brought up the 60B motion and that she was negligent. And she was. Judge Saines, Teresa Danks, or Magistrate Judge Teresa Danks, they were totally neglectful. Whether or not it's inadvertent or not, well, that's up for the courts to decide. I don't care whether this was inadvertent, whether it was on purpose or inadvertent. They did it, and they know they did it. They know they were wrong. Congress can enforce no law, can present no law that would interfere with the constitutional right of a citizen. They can enact no law, they can enforce no law. That's why you have stand your ground in a lot of these states now. It's because, and I'm not pro or con against it, okay? I'm not going there. But that's why they have it. They're saying that you have the right to protect your property. Well, I had the right to protect my right to put videos on YouTube, my religious videos here. If you look back, you can see some of my religious videos here. That's a constitutionally protected right, and you can't. No one has the right to infringe on those rights, unless, of course, you're abusing them. But that was never held out. Now, the appellate court can still hold that Trooper Coles has qualified immunity. However, he committed a misdemeanor, a Class A misdemeanor, and 2 Class B felonies. So, you be the judge of that. He abducted me and took me in when he shouldn't have. He should have told those people, you people committed a Class A misdemeanor. This matters for the civil court now. I'm out of here. And he should have left. But no, he didn't. You know, here's the thing, folks. On March 12th, 2022, Trooper Coles committed a Class A misdemeanor, as well as on or before March 12th, the witnesses against me, Richard Castellane, alleged victim, Diane Norman Button, Andrew Catello, committed this Class A. They disconnected my internet. Okay, I don't care what these courts say. I don't care if the appellate court says that wasn't against the law. It was against the law. It was a crime, folks. Look it up. New York, RPAPL, on your section 768. Look it up. The government is supposed to know these things. There were other crimes that were committed, but I don't even want to get into those. Every lawyer, every judge, every public official takes an oath to uphold the U.S. Constitution. That's right, they take an oath. I solemnly swear I will protect the U.S. Constitution. Oh, really? I don't think so. Because you see, this entire case developed because Richard Kessling and Company violated my rights to the First Amendment to the Constitution. I have not found a single court official that respects the Constitution yet in this matter. Beginning with the Stockton Town, New York Court Judge Daniel Vinyl. That guy's a joke. Oneida City, New York Judge Michael Miziazik. He's a well, I won't say he's a joke, but he didn't really do nothing. But he told me I should have pled guilty to a crime I didn't commit. And New York Supreme Court Judge Michael McBride. That guy's a liar. That judge is a liar. He accused me of making up or forging, or whatever you want to call it, emails. He's a liar. And the U.S. District Court Judges Brenda Saines, David Hurd, U.S. District Court Magistrates Mitchell Katz and Teresa Danks, and so far 3 Second Circuit Appellate Court judges. ASA, Assistant State's Attorney John S. Rogers, the attorney, the clown they appointed me named Brendan Rigby, and the Oneida City Court Clerk Carla Fitzgerald. This woman here manufactures emails as she goes along to support her case. She actually committed a fraud upon the court. Now, so far it's evident that these officers of the court do not know the First Amendment of the United States Constitution, or they intentionally chose to ignore that amendment for whatever reasons. Now, I have submitted prima facie evidence that Kessling and Company interfered with my right to the First Amendment by way of 2 emails dated February 2nd and 3rd of 2022, where Kessling said he didn't like Jehovah's Witnesses. He didn't like me, accused me of using his phone for Jehovah's Witness business, and I never had his phone. I never used his phone. I had my own cell phone. And he says I was using his place to conjure, to have meetings. And that never happened either. But also there's that body cam video. Now the body cam video was an AM and a PM taken on March 12, 2022. You had those witnesses informing Coast that they violated my constitutional rights. And then Trooper Coast violated my rights himself. Now, just apply everything I previously said to these officers of the court. Officers of the court know my rights were violated. Every one of these officers, every one of these judges know that my rights were violated. But, or they should have known. Since day one of this matter, back in 2022, I am just one of those pesky Jehovah's Witnesses, one of those people who knock on their doors and pester them on the weekends. Did they get even with this Jehovah's Witness? You be the judge. Have a nice day.